Hello, my name is Vironika Niharosev, and today I will be discussing the case of Bracklow versus Bracklow. It is a 1999 Supreme Court case. As a disclaimer before I begin, this presentation is for general legal information only. For specific advice, please consult a lawyer. Now, getting into the facts of this case, there was a woman and a man married in 1989. They cohabitated together for a period of 4 years prior to marriage. During the first 2 years of cohabitation, the woman paid for 2/3 of the household expenses. Both the woman and the man were in the labor force. After the first 2 years, they began to share household expenses equally. The wife subsequently had a psychiatric breakdown and went on EI for a year. At the end of the relationship, the wife had a physical and mental issues and ended up in psychiatric facility, and the man ended up providing support. They separate, and the woman gets $800 a month in CPPD, and there are no children from that relationship. However, the man is making $3,800 per month, and he remarries. When the case gets to the Supreme Court of Canada, the husband is making $6,000 per month. The issue that this case dealt with is how much support is owing and for how long. The reasoning, according to McLaughlin, the issue is whether the spouse has an obligation to support a former spouse over and above compensation for loss incurred as a result of the marriage and its breakdown. And that's what the case turns on. Now, to quote Bracklow at paragraph 1, what duty does a healthy spouse owe a sick one when the marriage collapses? It is now well settled law that spouses must compensate each other for foregone careers and missed opportunities during the marriage upon the breakdown of their union. But what happens when a divorce, through no consequence of sacrifices, but simply through hardship, leaves one former spouse self-sufficient and the other incapable of self-support? The court goes into discussing two types of marriages. The first is marriage of independent equals, where each spouse is able to be independent and there is some equality between their circumstances. Here, we want to compensate for any disadvantage, but once we have made that calculation, there should be a clean break. Versus the second type of marriage, which is an interdependent view of marriage, mutual obligation, otherwise known. The couple is so intertwined that it is difficult to unravel the interdependency that exists in this type of marriage. Need to look at an income security model of spousal support. Just because marriage comes to an end doesn't terminate obligation to continue to provide support if it was a marriage that involved interdependency. The reasoning. The court relies on section 15.26 and says that there is an obligation to pay in these circumstances to relieve economic hardship from the breakdown of the marriage. The court goes on to say that marriage is a serious commitment. While it does not necessitate till death do us part, it could lead to potential lifelong support. Non-compensatory entitlement, by virtue of the status of marriage, if you find yourself in need, one spouse has an obligation to the other. The court held that the appeal is allowed, and the matter was sent back to the trial judge to determine the amount and duration of spousal support award on the basis that the appellant is legally eligible for postmarital support. And this case can be retrieved by going on Canley and following this citation. Thank you for watching.